Hello, good afternoon, everybody. My name's Virginia Driver. I'm here with my colleague Tom to talk about turning your AI technology into valuable IP assets. So I'm a patent attorney and an intellectual property strategist with the firm of Page, White and Farrer. And Tom is my partner, similarly qualified. And we specialize in the field of AI, software and data science. So what we're going to talk about today is how to maximize your intellectual property value for the business opportunities that you hope to meet as a startup or scale-up in particular. So we are focusing this talk on those of you who are trying to make something of your business, and in that, running the risk of losing the value in your intellectual property. So we're going to talk about how you recognize the valuable intellectual property that you've created and how you crystallize that value. So one thing that very often happens in startups and scale-ups is the intellectual property is sort of given away in the course of your normal business activities. If you're trying to create a business based on a technology, you want to discuss your business with possible partners and investors. Down the line, you might want to discuss it with possible acquirers even. And in the course of these things, you'll certainly want to discuss it with customers and potential customers. And all of these discussions, while being absolutely vital to get your business up and running and be successful, can run the risk of destroying your valuable intellectual property. In particular, there's a very low awareness in startups in the field of software and AI as to what that intellectual property is and how the value of that can leak out in the course of normal business. And this can lead to a devaluing of your core intellectual property rights. And we're going to look today at how to remedy some of that. So why know this stuff? So we're going to tell you an overview of intellectual property rights. We're going to particularly focus on software patents. And then we're going to have a look at a case study which is directed at how to prevent the devaluation of your IP. And the reason you need to know this stuff is to make sure that having created this amazing new technology, you actually crystallize the value and enhance its value by properly leveraging IP protection. This was taken from a report done by the UK Intellectual Property Office, actually some years ago, but it's still very relevant. And it looks at how patents in particular can secure the value of intangible assets. And you will see on this graph there's three different colors: purple, orange, and blue. And each of these colors represent a type of asset and a type of value can be derived from your intellectual property. And in this you can see the difference between the colors. So the purple ones are probably more relevant to new startups and new emerging applications. And then the orange ones are more established companies, and the blue ones are very established uses of intellectual property. And we don't have to go into the detail of these here, that's not the point. It's just to show you the vast world of intellectual property and how it can support your business. So I'm going to hand over to my colleague Tom at this point, who's going to point out the various different intellectual property rights that you might rely on.
Thanks, Virginia. So a lot of time we see various sort of people discussing intellectual property rights and maybe some sort of slight inaccuracies or confusion around these different terms like copyright, trademark, patent. Actually, this is when you're into high risk territory as a business, because as Virginia has talked about, if you make certain assumptions about what IP you do and don't have and how it might be protected, if those assumptions then turn out to be wrong, that's when you leave yourself vulnerable to actually destroying some of these IP rights. And we're going to see how this works by looking firstly at what these IP rights are, because they're different legal rights that underpin the ownership or lack of ownership of your ideas and your technology. And we're then going to have a look at some of the limitations of these rights as well as their strengths, so that you can start to see where these risk factors are in a business in terms of crystallizing and securing your IP. So on the left-hand side, we have what we call registered rights. Now, in a sense, these are the strongest rights because you go through a process to register them. As we'll see in a minute, they give you some of the strongest protection. But you do have to go through a process of registration. You have to meet a number of requirements when you do that. And one of the crucial requirements comes down to timing of when you do it. You don't have the option of doing this anytime you like. You have to be strategic in when you apply for these things. At the bottom, we see what we call, generally referred to as copying rights. Now, these are rights that do exist automatically from the moment you create something. They require, however, copying. So they require someone to copy you. And actually, there are some other limitations around what it is that they're actually protecting in terms of what it is that other people can and can't copy. And what you sometimes see is an over-reliance on these rights. And the same is true, if not more so actually, on these rights that we see on the right-hand side. These are the sort of confidential rights, as we call them. These are certain rights that you get from the fact that information or knowledge or expertise that you hold within your company is confidential. Trade secrets gets bandied around a lot in tech companies in particular, but it is fundamentally a confidential right, and we'll see what that means in a second. So if we start with copyright, particularly in software, people have generally a pretty good notion, or at least an understanding that stuff they are doing, code that you're writing, original code, is protected by copyright. Now, copyright protects the expression of an idea, which in software terms means the code itself, not the underlying idea. It's also a copying right. So it only protects you around in software if someone has access to the actual code of your software and copies it. It doesn't protect you against them writing software that does a similar thing without copying it. And in fact, it doesn't protect you against someone copying your ideas. So someone can take your idea and recode it, and that's generally not an infringement of the copyright in the software. Confidential information. This is the sort of broad category of rights that includes trade secrets and know-how. It requires a duty of confidence, which means that you actually have to take active steps to keep this information confidential. And it is a valuable right for as long as that confidentiality is maintained. But it's important to understand that as soon as that knowledge enters the public domain, you no longer have the protection of confidential information. We talk in this third bullet point about the notion of independent derivation. If you have an idea and you keep it secret within your company and it satisfies the requirement of confidential information, you do have protection around that as confidential information until the point it enters the public domain. And that could be you putting it in the public domain yourself, or it could be someone else coming up with the same thing independently and putting it in the public domain themselves. And at that point, any protection you've got around this information under confidentiality no longer exists. So if you've taken steps to sort of, say, obtain signed non-disclosure agreements, to the extent those NDAs now relate to information that isn't confidential anymore, they're no longer valid. We'll see in a minute that actually this independent derivation doesn't even stop someone else from patenting the idea that you've been keeping secret and that you had first. Now, patents fall into the category of registered rights. So a patent is something that you actively have to apply for and meet certain conditions in order to be granted a patent. If you are granted a patent, it gives you what we call a monopoly right. Now, in contrast to copyright and the other copying right, this means that you don't require copying in order to infringe a patent. The protection given to you by a patent is defined by the patent itself. Someone doesn't have to have copied your idea to infringe that patent. They don't have to have known about the existence with your patent. It's a strict test on whether or not what they're doing falls within the scope of your patent in a country where it's in force. And patents can potentially protect broader concepts than software, than copyright, sorry. So whereas copyright protects the expression of the idea in code, patents can give you broader protection around the underlying technical concepts that then do give you protection, for example, in that scenario where someone takes your idea and recodes it, because they're still using a concept that is protected by the patent. Patents can last for a period of up to 20 years, which in the tech space and software space is a very long time in general, and actually most patents aren't maintained for their full 20-year term. Patent pending is something you see a lot. It doesn't really have a legal status beyond an indication that you have applied for a patent, but it can nevertheless be a very effective indication that you are taking your IP seriously, and can be an effective deterrent to entry, as well as a plus in terms of advertising your technology to investors and the like. So that's sort of what a patent is in the abstract. What do you actually have to do to get a patent? Well, you have to prepare this quite long document, particularly in software. It can be up to 50 pages of technical detail as well as legal definition, which is what a patent attorney is here to do. We write these documents for you. You have to file this patent application with the Patent Office, and it then goes through an examination procedure to see whether it merits granting of patent rights. Now, essentially what you're doing is putting in quite a lot of detailed information about the invention you want to protect, together with a definition of what it is you actually want this patent to protect. This does get published, which means it does enter the public domain, which means that going back to the confidential information point, once you've filed your patent application, there will come a point where the information in it is no longer confidential, and you don't benefit from those protections of confidential information. That doesn't happen on the day of filing. It happens 18 months from filing. And that's a little bit of a tangent, but it's an important point to understand. You file your patent application and you still maintain your confidential information rights for up to 18 months from filing. Now, having filed this document at the Patent Office, what is it that they're looking for in order to assess whether or not they're going to grant you a patent as you've asked for? Well, essentially, it's a relatively simple set of tests in principle and at a high level. The invention that you're trying to protect in your patent application has to be new and inventive, and it has to be directed to patentable subject matter. And that third one's a little bit of a cheat because it's stuck the word patentable into the definition of what you can patent, but we will address that in a second. Now, this first requirement, novelty, your invention has to be new. In a sense, this has its normal meaning, and in a sense, it very much doesn't. So in order to qualify as new, the invention must not have been made available to the public before the filing date of your patent application. Coming back to our notion of confidential information, what that actually means is it must not have been disclosed to anyone outside of your company who is not bound by a duty of confidence. Now, if we actually unpick this a little bit, there's sort of plenty of ways that stuff can become not new that are kind of intuitive. If someone else gets there first and publishes it in an academic paper or their own patent application before you, most people would understand that intuitively means your idea isn't new and you can't patent it because it doesn't satisfy this first test. The one that's a bit less understood is that actually the person who makes your idea no longer new can be, and often is, you putting it into the public domain yourself. So if you disclose your own invention to someone like a customer, a potential investor, a potential acquirer, you have destroyed the novelty of your own invention. And if you're doing that at a point when you haven't yet filed a patent application, then you now can't file a patent application because you can no longer satisfy this novelty requirement. So that brings us to the golden rule, which if you take away anything from today, this is an important one. You can destroy the novelty of your own invention And by putting it in the public domain, whether it's through an oral disclosure, publishing it, or whatever, just informal discussions, you can destroy the novelty. You can no longer get patent protection for it, and you've also destroyed your confidential information rights. And that's one of the biggest risk factors that Virginia was alluding to when it comes to the risks around the value of your IP. Now, that second requirement here, we're going to talk a little bit about, but not in great depth. It's important to understand that this is an objective test that is framed in a certain legal context and is not simply a case of you looking at your own idea and saying, is or isn't it obvious? So I said we'd address that third requirement, patentability, and I'm going to hand over to Virginia at this point to talk about the legal requirements around that notion of patentability.
Thank you, Tom. So just going into a bit of legal detail, what does that definition, patentability, actually allude to? Well, if you look at this section, which we've taken from the UK Patents Act, this says that the following are not inventions, and it actually calls out certain things as not being inventions, and it means they're not patentable inventions. A mathematical method is not considered to be patentable. A program for a computer is not considered to be patentable, and presentation of information is not considered to be patentable. Now, you'll be looking at this and thinking, well, we've just spent the last 20 minutes wasting our time because none of the stuff that we're doing, which is either maths or software or user interfaces, is patentable. But actually, the secret to this is all in those little red words at the end. None of these things are patentable as such. In fact, they all become patentable if they satisfy a requirement for solving a technical problem or they're in a technical domain. So a product or process or system which solves a technical problem is patentable. And I think you can all agree that most of what you're likely to be doing is solving some kind of technical problem. That's what you're spending hours and hours and hours of writing good software for and making good machines. So this can be software. So even though you can't protect a computer program as such, you can protect software if the software is performing a non-abstract function or a technical function. It's no longer software as such, it becomes software with technical character, and therefore you can get a patent for it. So similarly, with AI and machine learning, according to the law which is developing rapidly, I should say, in these areas, but according to the law in particularly Europe and the UK, artificial intelligence and machine learning are being categorized as mathematical methods. They're mathematical methods which are being implemented by computer programs. And from a legal point of view, they're treated as mathematical methods have been treated in the past, which is you can't protect a mathematical method. But you can protect technical applications and technical implementations of mathematical methods. And therefore, you can definitely protect implementations of artificial intelligence and machine learning, which are technical and which have technical applications and technical implementations. And I'm just going to briefly look at the dividing line between those two things. So when we're talking about a technical application of artificial intelligence, we're talking about the use. So the use could be something very concrete, like using AI to guide a factory, using AI to control a physical machine, using an AI to generate drawings, computer-related drawings or something. Those would be technical applications. A technical implementation is what's going on inside the AI itself, inside your machine learning model. And these could be characteristics of the way that the model works, the way that the model uses computer memory, the way that the model uses computer resources. These are all areas where you might make technical improvements and where you might be able to seek a patent. So let's just look quickly at that last requirement of Tom's about inventive. In order for something to be inventive, it has to be non-obvious. But non-obvious to who? Well, it's not you. It's not the inventor. Most of you are entrepreneurs. You're highly skilled. You're working in a particular context where you've researched for a long time to establish your own technology. That's not who the patent offices have in mind when they're assessing the test of what is obvious. They have a more objective test in mind, and they take this hypothetical person of ordinary skill. And a person of ordinary skill is supposed to have basic knowledge in the field, to have read widely in the field, but not to have any inventive imagination. And in particular, this skilled person does not have hindsight, and he does not have your particular context. So all I really want to say about this, if you take away anything from this talk, well, please take away the golden rule, Tom's golden rule, but also don't judge obviousness of your own ideas, and don't let your immediate peers judge that. It's an objective test that patent attorneys are much better placed to make an assessment of. So thinking about this and kind of quickly summarizing where we've got to, when should you come and talk to a patent attorney? Well, when you've solved a technical problem. So at the point at which you recognize that your technology is new and that your technology has actually solved a technical problem, sufficiently well developed, you've looked for an off-the-shelf open source solution, you couldn't find one, your solution meets a market need, then come and have a chat to us. You don't have to have fully written the code. You don't have to have a working prototype. All you need to know is that actually you're in with a shout with this idea. This idea is good, solid, it will work, and potentially it's going to be a successful business for you. At that point, please come and have a chat with us, and we can tell you whether or not we can crystallize your intellectual property into some valuable rights for your business. So just going back to a little bit more concrete, some specific examples of the kind of things that you might be able to get patents for. Now, these are things that people have got patents for. Looking at the technical implementation or technical application of software. An interface with a field to take feedback from a user that certain outcomes of text classification by an AI model were to be discarded in a next round of predictive suggestions. And it was determined that this was technical from two standpoints. One was the relationship between the user interface and the user. So the user interface made it very easy for the user to provide this certain specific feedback. And then this feedback was provided back to the AI model in a very specific manner to say these things need to be discarded in the next training iteration. That was considered in the context to be new, and it was considered to be not obvious, and it was also considered to be technical. Another example, a medical billing classification scheme where a text classifier gave a billing code and a confidence rating as to how accurate the billing code was. The confidence rating was used to control if a query got passed to a clinician through an API. Now, the technical piece around this wasn't the accuracy of the billing code. What it was the determination as to how to route the particular message based on that confidence rating of accuracy. So you can see here, these are quite fine lines, and you definitely need help in determining which bits of your technology are patentable and how best to frame them in a patent application. So another set of examples which are more general software, a video communication app for dating with gesture-controlled video obfuscation, a new data structure for implementing game physics. And actually, although we didn't point it out, one of the things that the patent offices don't regard as being inventions are methods of playing a game. But computer devices, which are configured to provide user interfaces, particularly set up to solve technical problems in playing a game, are patentable. Embedding a payment token within a digital identity verification message. Again, one of the things we didn't call out on that earlier slide, the Patent Office does not consider methods of doing business to be patentable, but they do consider these things to be patentable in a technical context. And in this case, the embedding of a payment token into a digital message satisfied that test. So again, we're back to this very fine line of what is and isn't patentable in your technology. So you do need to chat to us. So I'm just going to hand back to Tom to go through a case study which looks at some of the particular issues that startups face when they're looking at the intellectual property and how to maintain the value in that.
Thanks, Virginia. So this case study, it's a hypothetical, fictional company, but that said, all of the things that I'm going to talk about in the context of this are things that have actually happened to at least one, if not more, of the kind of tech startup scale-up companies we've worked with over the years. So our fictional data science limited company is a startup with specialist expertise in a particular data science problem. And they provide support and software services to their customers to essentially help them unlock their data. And their customers are larger companies. So the customers have the data, and the startup has the expertise and technology for unlocking specific value and insights in that data. And if we have a look at their sort of pipeline at a high level, there's plenty of stuff that's familiar in there, and they probably use plenty of their sort of open source off-the-shelf stuff. But in conjunction with that, a few really key pieces of bespoke things that are unique and valuable. So I'm going to focus here on their user interface and their APIs in the front end. And these, starting out from a sort of good idea about how to present this data, are then refined over many product iterations to provide a really good user experience, and is actually one of the core pieces of novelty that is then driving customers to their platform. As well, if we look in the back end, there's also some core AI and analytics around how they're actually doing this analysis that together with the kind of know-how and expertise of their data scientists and engineers is really what's then sort of the magic in the back end that's making it all happen. Now, the startup sort of takes this view that, okay, we know we've got something valuable in the back end. We know this is our kind of special secret sauce. It's going to be locked down. We're going to rely on trade secrets. It's our core IP. It's protected by trade secrets, and that's the story we're telling. Not much thought around what actually that means in terms of different categories of IP, or what it actually means to be relying on trade secrets. The assumption within the company is that because this stuff is key and important to the business, and because it's in the back end, that it is just protected by trade secrets, because surely it has to be. It couldn't not be protected. And again, because they haven't had the sort of insights around what Virginia was talking about, around what you can protect around user interfaces and APIs, it never even really had the thought that this is something that conceivably you could actually take steps to protect with a patent. So what happens? Well, in the first few years of the business, it's neither here nor there. No one is really that fussed about IP. It hasn't really cropped up. They maybe have some initial investors who as it happens, IP hasn't been a particular focus for them. They've been much more interested in seeing that you have a business plan and you know, prospects of revenue and the expertise and everything within the company. And that first mover advantage from having cracked this particular problem in data science really does give the company an edge for a year or two. And they do very well and are able to secure good deals with these customers, and it's all good. The issue is that any first mover advantage does diminish over time. And this can manifest in a number of ways, but in this example, one of their biggest customers, who as I say, is also a tech company, a bigger tech company with their own data. They have an in-house team of engineers. They have a CTO, and their CTO takes a look at what's going on and says, well, we're actually spending quite a lot of money on these external companies. We have all this expertise in-house. I think we can take this analytics in-house and build our own system for doing it. So thank you very much, but we won't be requiring your services anymore. Now, at this point, it might be that the company starts to think, well, actually, surely protection intellectual property, they can't do this. They can't just sort of essentially take what we were doing and do it without us doing in-house. Surely this tech, my tech's proprietary, surely. Now, if we trace back over time, in the very early days of the company, that is true, because you've got a small number of people, you've got some genuinely new ideas that no one else has had before, and they're all internal to the company. In those early days, you have plenty of confidential information within the company that would benefit from those rights around confidential information if the proper steps are taken to secure it. But what we actually see happening in those early days is that even in those very earliest discussions, we talked about near the beginning, oral discussions with potential investors, potential customers, all of this stuff is actually leaking high-level information out of the company. Now, maybe these are under NDA, maybe they're not, but even if you have NDAs, there comes a certain point where any court or authority is going to look at that and say, well, if you've discussed it under 20 separate NDAs with 20 different parties, you haven't taken proper steps to protect that as confidential information. Those NDAs aren't valid, they're just pieces of paper. So now a lot of this stuff is actually into the public domain, which means if we're looking at confidential information, it no longer has that protection around confidential information and trade secrets. And it also means it's no longer new from a patent point of view, so you can't protect it with a patent. Now, the company has some awareness of this maybe, but still has this notion of core IP and trade secrets that are locked down. Even as the other stuff around the user interface, some of the higher level stuff comes out, there is still this notion that there's this core piece of analytics in the back end that's driving it. But actually, it's rarely that clear cut, particularly when you're in a situation where you've been having ongoing discussions with the in-house technical people at your own customers in this case. And what you actually find is that over a number of years of properly supporting their companies and helping them to integrate with their system, actually a lot of that core IP and trade secrets has leaked out in those discussions. Softly, over time, you can't point to any one individual discussion maybe that's really scuppered it, but to the extent it's leaked out of their company, it's no longer protected by confidential information, and there's nothing else to make that gap because they haven't applied for patent protection. Now, actually, in reality, it's probably even worse than this. So when you actually drill down and think, well, maybe there's still some stuff there in the back end that we haven't shared with the customers, there's something still we can protect there to give us some leverage. It then turns out that actually it's far worse than anyone thought. So a real example here, a PhD student who interned for 6 months, it turned out included key details of some of the core algorithms, the back end in their PhD thesis. That's now available in the university library and is therefore no longer new because it's now in the public domain because anyone could go and pick it up. So what you actually see here is a diminishing of these rights, an expertise that is no longer perceived as leading edge, and really not much in terms of intellectual property at all to help them in those negotiations with their customers when they're trying to persuade them to keep them on board. Now, it won't surprise you from what I've just said to learn that it's now too late to then go back in time and patent it, because to the extent this stuff has leaked out into the public domain, it's no longer new. They didn't follow the golden rule, and that opportunity to get patent protection is now gone. So I'm just going to hand back to Virginia now to finish up and just think about how could things have been different.
So how could we get that curve to go from a red downwards curve, which nobody in the business world likes, to one of these lovely upwards curves, which everybody in the business world is very fond of? That's what we like to see. We like to see things growing, not diminishing. So if the startup had applied for patent protection before the user interface and the core analytics methods entered the public domain, that would have made a huge difference. That could have leveled the playing field in negotiation with their customers, advertised and defended their innovation, and in particular in relation to these scenarios that Tom went into, where a bigger company just decides we don't need you anymore. But if you have a patent application or a patent, you can discuss licensing with them. You can say, well, actually, you may not need us, but you might need these rights in order to carry on. Furthermore, the company forgot to apply the golden rule. They allowed their technology to leak into the public domain, and so it rendered it not new. But notice also that because the patent application would remain secret for 18 months after filing, they could have the advantages of having that patent application in place without any of the back-end information becoming available to the public by way of the patent application. So they maintain their first mover advantage. So there really is everything to play for if you file a patent application. You can protect so much by doing that. So what next? Well, you now understand that you need to protect your innovation somehow, but you don't know where to start. We've given you some pointers. But of course, that's what we do. So please get in touch with us and we can help you. If there are any questions, please let us know.